Challenging evidence, the exclusionary rule in Oklahoma. I'm Tulsa attorney James Wirth. That's a topic that we have. The exclusionary rule in criminal cases, it's helped to enforce constitutional rights so that if a defendant's rights are violated, you have a remedy that makes a difference in the criminal case, and therefore a remedy that is going to matter to prosecutors and law enforcement so that they can act better in the future. So what's the exclusionary rule? Well, it's essentially where rights have been violated in such a way that allowed the state, through law enforcement or elsewhere, to get a benefit. Sometimes that's in additional evidence. Sometimes that's by hiding evidence. But in either way, if we want to deter that sort of activity, then there needs to be repercussions, and the repercussions is part of constitutional law, and it's not just applicable in Oklahoma. It is a United States Supreme Court precedent, but it's going to be applicable in Oklahoma as well, where we practice and deal with these issues. So what type of rights violations are we talking about? Generally, we're talking about Fourth Amendment rights violations, Miranda rights violations, or perhaps a Brady or discovery violation. So if we've got a client that was pulled over and there wasn't reasonable suspicion for that stop, and then there was a search done without consent or without probable cause, and some sort of contraband was found, and then they filed charges based on that contraband, well, they violated the law in illegally detaining you and searching you, so they shouldn't have the opportunity to use that evidence against you. And that's where the exclusionary rule comes in, where you file to exclude that from evidence and then a dismissal, because without that evidence, they can't make their case. So if you can demonstrate that your rights were violated and that the fruits of that poisonous tree, meaning the contraband, the evidence they use against you, should not be admissible, and the court should make a ruling that it is inadmissible. And at that point, if the state doesn't have sufficient evidence, or other prosecutorial authority does not have sufficient evidence for a conviction or for probable cause to move forward to trial, then the case should be dismissed at that point. And that can be brought up at preliminary hearing. It can be brought up at a motion hearing. It can be reissued in motions in limine. And then you'll also want to bring it up, if it's denied, then at trial, so you can preserve that for appeal. So that's Fourth Amendment violation. The other one's a Miranda violation. So if you are detained and then you are asked questions which could reasonably produce an incriminating response, then under United States constitutional law, you're supposed to get your Miranda rights, where they advise you that what you say can and will be used against you. And if you then note those rights, but then you voluntarily agree to speak, then that's one thing. But if you weren't advised of that and you speak, well, that's a violation of Miranda rights. And what's the repercussion of that? Then you can file for a hearing to determine if those statements can be admissible. And if your rights were violated, the court should rule that those would be inadmissible, can't be used against you, because we don't want to allow law enforcement to break the law, to violate your rights and get the benefit of being able to prosecute you because of that violation. So that's where the exclusionary rule comes in. Elsewhere we see it's a little bit different, but still punitive for bad acts. If we've got law enforcement hiding reports or the DA not providing sufficient discovery, that's a Brady violation. And as a punitive measure, not that it's fruits of the poisonous tree like in the other ones where it's typical and exclusionary, but here's a punitive measure. Because they hid evidence, they should not be allowed to use that evidence against you. You could request a ruling and a motion in limine on that, or if the violation of the rights, the Brady violation, is sufficient enough, that should be grounds to get a dismissal alone. But if you're dealing with these circumstances, you're going to want to talk to an attorney privately and confidentially about your specific case to get legal advice that's actionable for you. To do that, to talk to an attorney at my office, you can go online to makelawEasy.com.